Matter of Monaghan v. Schroeder?
Good afternoon. I'd like to reserve 2 minutes for rebuttal, please.
Yes.
My name's Eric Sills, and I represent John Monaghan, the petitioner in this action. I think it's fair to say that prior to respondents' response to the petition in this case, no one who practices in the field of DWI law would have ever dreamt that CPLR Section 2308B could possibly apply to a DMV chemical test refusal hearing. It literally had never come up, ever. It's fair to say that I have immersed myself in this field for close to 30 years. I know all the other relevant people who have done the same.
But Counsel, 2308 doesn't apply to DMV enforcement hearings. It applies to subpoenas. It's a mechanism for enforcing a subpoena.
Correct.
So why wouldn't that, any subpoena issue, assuming you're talking about subsection B, any subpoena issued by any attorney in New York could be subject to one of those proceedings?
Well, the first three words of the section, 2308B, are unless otherwise provided. And in this case, it is otherwise provided.
There's a subpoena enforcement mechanism at the DMV?
What's provided is that the CPLR in general does not apply to these hearings. It specifically says that. It specifically says that.
Well, it doesn't say it doesn't apply, right? It says it doesn't have to be applied, something to that effect.
It says it's not binding, that's the actual language, but then
It
later
doesn't mean
down
right.
in the section, it does say specifically that the provisions of those laws regarding, the laws being the CPLR and the CPL, regarding forms of pleading, motion practice, discovery procedures, and other matters are not applicable in accordance with this part. So anyone reading this and anyone who practices and hears DMV judges constantly remind you that they are not bound, that the CPLR doesn't apply and you can't invoke these rules of the CPL or CPLR, and you're constantly over
But doesn't that mean to affect the conduct of proceedings themselves? If a litigant were to invoke the CPLR in the course of a hearing in front of the DMV to say, you can admit this or you can't admit that, or that's a good question, that's not a good question, I could understand that. But again, they sort of teach you in New York procedure that you have actions and you have special proceedings. And to me, this is more like a special proceeding to enforce a subpoena, quite separate and apart from what's going on at DMV, other than the fact that the person sought to be produced is going to be a witness in a DMV hearing.
That said, Your Honor, if in your practice, in the real world practice in front of these judges, if when you subpoena the officer and the officer doesn't show, you win, and everyone
What's the authority for that?
I'm sorry?
What's the authority for that?
The authority for that was this matter of Dale appeals board decision that is not written, as articulately as one might like, but has always been read to mean what I'm saying, which is if, Gravy Aducci said you can't complain if they don't show because you could have subpoenaed them. And so it's always then been taken that if they don't show, and keep in mind, twice, because for some reason they're allowed to not show the first time and inconvenience.
But all of that seems to be you're relying on practice and what you think people understand to be the law, but we don't operate like that. Like, we need rules and we look at statutes and we look at case law, and I'm asking you what your authority is for saying that these cases should be dismissed as opposed to just enforcing the subpoena.
So let's assume that respondents are correct, and let's assume that the court believes that 2308B does apply to these hearings and it's been misread for decades. Then you still...
I'm sorry, what's been misread for decades?
That
2308?
2308B, where DMV has for decades been dismissing these hearings where you subpoena...
But again, what we're struggling with, I think, is how can we take note of what you're telling us. I think a citation to an administrative decision from 1997, we would expect to see more of a demonstration that that is the settled practice than simply this. And if you're relying on something beyond Dale, if I'm pronouncing it correctly, it would be helpful to know what that is.
Well, page 156 of the record is a 2017 decision that reaches the same conclusion.
But those conclusions, if I'm getting it right, are that if you, certainly in Dale, if you have failed to subpoena the officer and the officer doesn't show up, you lose. No?
No, that's not correct, Your Honor.
That's what, in Dale, there was not a subpoena, no?
No, it was no, in Gray v. Aducci,
Yeah.
if you show the first time and the officer doesn't, they adjourn. And then you come back, and if the officer doesn't show, they can go forward on the papers.
Right.
But you don't, lose, you can...
Well, the
okay,
papers presumably have the evidence, right.
But
yeah.
you just would have to go on a hearsay...
Right, but the thing that is not resolved, I think, right, by either Gray or by Dale or anything, is whether you need, after having subpoenaed the officers administratively, to go and enforce that. Now, you say that can't be done, but let's suppose for a moment that you can actually use 2308B to subpoena an officer. Then it seems to me the question that you need to answer is that violative of due process? In other words, why would it be too much of a burden to have to go get a judicial subpoena to enforce, judicial order to enforce your subpoena?
Because, quite frankly, at these hearings, most of the people who go to these hearings don't have an attorney, or their attorney is the public defender who oftentimes, if not most of the time, says, this is a civil matter and we don't represent you there. So most of the time you have people who don't have an attorney at all.
Well, how would those people know to get the administrative subpoena in the first place?
They wouldn't. So they're already being burdened, and their right of cross-examination is already being unfairly limited, but that was decided in Gray v. Aducci that that's okay.
You know,
But-
there are a number of appellate division decisions that I read in which other kinds of determinations, for example, disability retirement benefits or unemployment insurance benefits, there's a hearing and there is a subpoena, and the appellate division says, you have to go enforce that yourself. Why would it be different for a driver's license revocation or suspension than for those benefits? Or is it your view that those are wrongly decided too?
No, it's meaningfully different. As I point out in my brief, if you look at the regulations at issue in each of those cases, those regulations are meaningfully different than 15 NYCRR section 127.11. Those regulations, at a minimum, apply to subpoenas should be handled in the manner pursuant to the civil practice law and rules, generically.
I think that goes to whether you think that the enforcement mechanism is applicable. But I'm saying if we conclude it is available, then why would the nature of the interest be different, such that a different rule would apply?
The nature would be different also because in a typical hearing, the person who's being subpoenaed is a civilian and not a police officer. Whereas at a DMV hearing, a refusal hearing, it's almost always a
So
police
you
officer.
have to enforce against a civilian but not a police officer?
Well, I would say that as an officer of the law, a police officer is obligated to comply with a subpoena. Like, it's kind of outrageous, really, that someone who is...
That was Chief Judge Kaye's point in dissent, but it was in dissent.
Correct,
Right.
and it was a 4-3 dissent, and it could be decided, either that we should revisit this and go the other way, or it could be decided that this is even an extension of the next step. Like, we're going to shift the goalposts even further, where even though you did what Gray v. Aducci said you should do, and you did try to exercise your rights by subpoenaing the officer, then the officer can just literally blow off the subpoena, and now you have to run to Supreme Court, which, like, no one would, quite frankly, know how to do who practices in this field. We'd all have to learn it. I mean, it's not that you can't learn new things as you get older, but it's never come up because the reason we know that what I'm saying about how it's always been done is accurate is because there's never been a published decision ever where this 2308B has ever applied at a DMV hearing, whereas the first time it's ever been brought up, it comes all the way to the Court of Appeals. So it's inconceivable that DMV had not been dismissing, as I say, these hearings when you subpoenaed the officer and they didn't show. And because that's just how it, so DMV had always taken the position that I'm taking. It's just that Mr. DeMuth very creatively, because he has a broader knowledge base than criminal defense attorneys, he's the one who must have said, wait a minute, how come they're not applying 2308B? But because no one ever dreamed of it. No, I've never heard an ALJ mention it. The appeals board's never mentioned it. I've read, it's fair to say, every...
Yeah, but then the question, again, is, so not in the imagination of DMV or those who practiced before it, but nevertheless, there's no barrier, no obstacle under the statute
But however, let's
to require it.
Let's assume that's correct, and that really everyone's been wrong, including DMV, for 40 or 50 years, and that we really need to change it. This court has a well-settled doctrine that if there's been a precedent in place, the agency doesn't have to follow it, but they have to explain why they're not following it. Otherwise, it's arbitrary and capricious and requires reversal. So that doctrine, even if you say...
Well, other than saying it's never happened before, there's not really a record that shows that indeed there has been a specific approach, interpretation, course of action, and they have now deviated from that.
Well, I would say the lack of this ever coming up in a published case is precedent.
Well, let's see what Mr. DeMuth says about that.
Okay.
May it please the Court. Hello, Your Honors. Owen DeMuth on behalf of the respondents. Your Honors, all the department is really saying here is that when a motorist subpoenas a police officer at a chemical test refusal hearing and the officer doesn't appear, the remedy, and he has a remedy right in the statute, is not compulsory dismissal on due process grounds of the entire hearing, but rather...
Can we start with the point we were just on, which is what has the practice been?
The practice has been, and I think what that highlights, Your Honor, is the fact that the majority of his claims are not preserved. They're not preserved under subpoena.
I was trying to ask a different question, a factual question. What has the practice of DMV been when someone, is his representation correct?
No.
Why not?
It's not correct. His field delivery violation claim is simply not correct, and had it been preserved, had it been raised, it could have been raised before the appeals board, it could have been raised in the Supreme Court, right. But it's not correct. If we had the opportunity to respond in Supreme Court, we would have had the opportunity, as noted in Tolero, to make a factual showing and to take legal counter steps to show that there was no violation.
And what would that showing have been? Is it not the established practice? I understand it's
Yes.
outside the record. I'm just asking you to explain to us.
Not the established practice, Your Honor, that there was no, contrary to counsel's testimony about his experience aside, there was no established practice, there was no agency-wide precedent.
Is there any appellate case law applying CPLR 2308 to those hearings?
Not to a chemical test refusal hearing.
Correct.
But it's applied in a wide variety of other administrative...
Specifically to...
But not specifically to this. But, again, that's a policy argument he makes, that there's something special about a chemical test refusal hearing that precludes application.
Aren't these hearings supposed to be prompt? Would that not be a reason why they've not been applied before?
I'm sorry, prompt?
The hearings are supposed to be prompt. If you've got you go, you get the subpoena, you get it served, you're then going to lay on a layer that you've now got to bring another proceeding in Supreme Court. Doesn't that slow down a process that's supposed to take place expeditiously?
Well, not so much as you might think, Your Honor, because the department's regs actually speak directly to that. 127.7E3 provides that if the motorist seeks an adjournment for the purposes of getting a subpoena or for any other reason,
But you've sought a subpoena. The officer just chose not to abide by it.
right.
So why should you have to go to Supreme Court for enforcement?
Well, because it's consistent with what this court held in Gray. It's consistent with the CPLR. There's really no reason for precluding application of 2308B here, and I don't think petitioners provided.
An extension of Gray, I think. On another front, has Mr. Monaghan's license been restored, if you know?
My understanding is that the underlying criminal matter has been dismissed, and I think counsel could confirm.
I'm sure, yes, and we
Yeah.
can ask. But if that's correct, what's then before us that remains? It looked to me like Mr. Monaghan asked for, declaratory relief and for reinstatement of his license. Is there still a live controversy if his license has been restored?
Well, the suspension, the revocation would still be on his record.
So that's what would be at issue
I believe
still.
that still,
Okay.
would prevent this from being moot.
Thank
But Chief Judge Wilson, I think it was you who had asked what the practice is, and this is what we would have shown. First, we would have attached to our opposition in Supreme Court, if we had the opportunity, something called an ALJ safety hearing manual that was implemented in 2018, 3 years for the hearing in this case, which is in 2021. And that was prepared specifically for use by the ALJs in conducting chemical tests for refusal hearings. And the manual expressly contemplates a subpoena should be issued under CPLR 2302 and enforcement sought under 2308B. So it directly counters the claim. Under Tolero, this is something we could have cured.
Is your position that the practice is that if an officer doesn't show up after the second time the case is not dismissed? Is that what you're telling us? You think that that's not the practice, or is that the practice?
It's not the practice. And to the extent that it might have been, there might have been ALJs doing that before the manual took effect in 2018. My understanding is that there were some dismissals, but it wasn't
It wasn't a
pursuant to any
routine-
formal rule.
I get that it wasn't pursuant to any rule. I'm just saying, like, what was the practice, and what did people understand that practice to be when they came before an ALJ in this type of hearing? That if the cop didn't show up on the second time, that this case would get dismissed?
Well, no, actually, the department's regs are directly counter to that, and these were regulations that were in effect at the time. That's 127.9C, which we do cite in our brief. That provides, and I think this directly counters the field delivery violation. It says if there's a first non-appearance by the police officer, then there must be an adjournment. If there's a second one,
An adjournment to get a subpoena? I'm sorry.
or
over
just
here.
an adjournment in general to, certainly he has the opportunity to do it at that point, or just to, see if the officers will show up again.
And what happens, I mean, I know you're talking about we keep asking about custom and practice, and you keep talking about regs, but let's stick with regs.
Well, I'm trying to explain what we would have put in about the custom and practice, and the first one would have been the manual, and which is a rule, which does apply to all the ALJs, and that was in effect 3
I'm
years.
just not sure I understand the connection between the manual and custom and practice. If your adversary gets up and says the custom and practice is if the officer doesn't show up after they've been subpoenaed, the hearing is dismissed. That's the practice that is most striking in his presentation. I don't think a manual answers that question.
I believe it does. Well, at least, again, outside the record, this whole case is just awash in extra record materials, which is
But I don't think
unfortunate.
that that's his position. His position is that the first time you get an adjournment, but the second time, it was customary
Right.
that this case would be dismissed. And all I want to know is that your experience? Is that true, or is that not true?
No, my experience, again, what I have learned and my understanding of what DMV has done is since 2018, that has certainly not been the practice.
Before that?
Before that, there were ALJs, not pursuant to any field delivery
Yeah,
precedent or
yeah.
rule, but
And
there
he
were.
explained that he's been practicing for a number of years. So both things can be true. You're saying 2018, even if it did happen before it changed.
It did.
There were no
And
longer
to the extent it
dismissals.
happened before, I think it's important. He's making a field delivery claim. There has to be.
What do you say about due process? I subpoenaed somebody. This isn't one where he never even tried to subpoena the witness.
Right.
And quite frankly, one would normally expect a law enforcement officer to appear when they're duly served with a subpoena. What about his due process rights?
Well, we're saying that before you can really state that, there is a process. You know, it's not just the subpoena issuance statute, but it's also provided by the enforcement statute. And all we're saying is that
It's
before he
all
can state,
on the petitioner. The petitioner's got to do all of that.
right,
So there's no responsibility
Well-
on the part of anyone else.
yes, a
Even though-
couple points.
Even though the administrative judge can take away your license, they just kind of keep pushing the rock up the hill, even if it keeps falling back. They've, all these extra things.
Well, I don't know if it's an extra thing. It's just one additional step beyond what was announced in Gray.
A subpoena.
And
Normally
the
you
ALJ
re-
has no power
What about the
to.
fact that when you have a subpoena,
Mm-hmm.
that's doing the, in normal trials, normal civil practice, criminal practice, you subpoena someone, there is an expectation. Now, in a criminal case, of course, the judge is already there and can issue a warrant. But you're saying in these proceedings, even after you do the subpoena, even though the officer hasn't shown up twice, even though, unlike in some of the other instances where there was no subpoena, there was actually a subpoena, they still don't show up after the second time, it's still incumbent on the motorists to now go to another forum. That is what you're saying.
We're saying that is the plain meaning of 2308B, and it was incorporated by the
And not
department's regulations.
violative
And part
of
of that,
and not violative of due process to do it that way.
it's not violative. It balances, I believe, just by saying you need to go this additional step.
The license is reinstated once the officer doesn't show up the first time?
No, the first time there's just an adjournment, there's a
Okay, so the
mandatory.
license is still not reinstated at that point. Is it ever reinstated out at all
If-
during this period?
If, and I think I was trying to mention this before, the regs do provide that if they seek an adjournment to either get a subpoena or enforce it, the ALJ has an opportunity, it's a discretionary exercise, but the ALJ has the opportunity to reinstate the license
Is that
while
what
he
happened
goes to
here?
Supreme Court to get the subpoena or issue it.
Is that what happened here? Was it reinstated when he went to get the subpoenas?
No, he sought the subpoenas after the first adjournment, and he never asked for an adjournment in order to enforce.
So when we think about the benefit to the state of having the extra requirement of enforcing the subpoena and the relative burden on the motorist to go get the subpoena, how do those things, for a due process analysis, how do we
Right.
compare those things?
Well, I think it's
What does the state get out of it, I guess is what I'm asking. I can imagine what the burden is.
well, I think it's a reasonable balance, and I think it's important. Yes, Gray didn't talk about what happens if a subpoena is actually issued but not complied with, but the CPLR is, that's why people do this every single day in Supreme Court actions, administrative to
And
enforce subpoenas. This is not that
that
burdensome a
that
step.
goes to the burden. I'm asking particularly because I can imagine what the burden is. I've
Right.
had to go enforce subpoenas sometimes myself. What's the benefit to the state, as you had articulated, in having that extra requirement that you go out and get your subpoena enforced?
Well, it's a benefit not only to the state, because I think it's a nice balance between the liberty interest the driver has in maintaining his driver's license, but also, as you said in Dar Caicedo, the interest in letting these proceedings be completed so we prevent the grisly toll that drunk drivers take on the road. So I think that's a nice middle ground, saying, okay, look, you issued the subpoena, but now we're just saying you need to, it's a fairly pro forma application. All they do is they go to Supreme Court, they're not seeking contempt, they're not seeking the sheriff to get involved, they're just
Hold
asking.
on, I'm sorry, can I just, a point of order on that last thing you said? The remedies under CPLR 2308B, unlike A, it doesn't call it a contempt of court, but the remedies are largely the same. They include costs to the successful litigant, they include a fine to the non-compliant subpoenaed individual, and they even include the possibility of the court issuing a warrant to have a sheriff bring the person before the body that they're sought for. Is that really what DMV wants?
No.
Do they want judges issuing warrants?
No, and that's I'm glad you pointed that out, Judge Carantero, because that is the difference between a judicial subpoena and 2308B, a non-judicial subpoena, because the first thing you do.
No, but the warrant requirement is in the warrant option is in 2308B.
It only happens if all we're saying that the only additional step the motorist have to take here is to get that order compelling compliance. I think that's attached to a $50 cost order, but there's nothing else. if a judge issues a subpoena and it's disobeyed, you can go and get everything. You can get contempt, you can get fines, you can get the sheriff involved. That's not here.
Yeah.
All there would be
No,
would
but
be
what
an
I'm
order
saying
compelling.
is 2308B includes the same remedies. I could envision a judge, look, I was a trial court judge. I know when you enforce subpoenas, usually the first order is you must comply with this subpoena.
Yes.
But I'm saying under this statute as written, a judge could conceivably, if they thought it was justified, not just write an order that says comply with the subpoena, they can issue a warrant to the sheriff to bring the person before the body that seeks them. And that seems like a very sort of extreme thing to do to a state trooper. And I'm just confirming that DMV's open to that possibility.
No, I don't read the first step of actually getting that order of compelling compliance. I don't see, from what I read about in the practice commentaries, that does not permit the judge to actually go that far when you've just asked for the order of compelling compliance. Yes, if there's still noncompliance, all that's on the table. But I'd like to make clear that all we're saying is we just would like the motorists to complete the process available to them by going that additional step. If for some reason this police officer still did not show up, we would want the hearing closed. Unless there was some extraordinary circumstance, in the majority of those cases, that would be the end of the matter.
Does the answer to the due process question, in your view, get resolved as a bright line rule? In other words, yes, the requirement to enforce the subpoena violates due process, no, it doesn't? Or is it something that should be decided on a case-by-case basis, depending on what opportunity there is to cross-examine? I ask because there are some appellate division cases which suggest you look on a case-by-case basis at what else is in the record and so forth.
Yeah, and a lot of this will be on because of the discretion given to the ALJs. They have.
You're not asking for a bright line rule one way or the other, that enforcement, requiring enforcement does or doesn't violate due process?
Yeah, I guess to the extent that I'm seeking a bright line rule, it's not a particularly novel one. It would just be, consistent with the way the appellate divisions have already read 2308B in different administrative contexts, that, if there's noncompliance, the process available and the process that you need to complete is to go that additional step and get an order, not compulsory dismissal. And I think that's consistent with Gray, it's consistent with CPLR. I mean, that's exactly what that statute's there for. And the department's regulations do incorporate that, contrary to petitioner's argument. This is something that we could have interpreted in the Supreme Court and which would have been entitled to deference. And there's three reasons why. The first is the ALJ has no power to issue or enforce his own subpoenas. That's not in dispute. Petitioner has never disputed that. The ALJ, some agencies do, the department here in a refusal hearing does not. The second is that 2308B states that applies, quote, unless otherwise provided. And the appellate division cases have interpreted that to mean that unless the agency has been given a specific grant of power in either its enabling statute or the regulations, then 2308 applies. And in this case, there was no specific grant of power, so we default to 2308. And just reading 127.11a, which is what petitioner relies on for the regulatory argument, I think the most natural reading of that, the most reasonable reading, is that it just excludes application of the CPLR as far as it contemplates. You don't need to do formal litigation devices that would happen in a plenary action, such as discovery or motion practice or bills of particulars. They're not applicable to hearings. That's the language, but I think, Judge Canatari, you touched on it before, that wouldn't necessarily apply to a special proceeding. That doesn't speak to a subpoena enforcement, which the CPLR provides, is done separately in a different venue in Supreme Court. So I think those regulations and the CPLR itself, work in harmony with each other, and they provide, and I think it's just, as far as the due process argument goes, it's a reasonable balance. We are extending Gray. We're going, because Gray didn't have the opportunity to talk about enforcement, but I just think that all we're saying is that he's not entitled to dismiss the whole thing. He could proceed without, he doesn't have to seek enforcement. He can certainly proceed, and many times, one thing that's important to point out, the majority, there are about 6,000 of these refusal hearings held every year. The vast majority of them, subpoenas are never issued, and that's by design. That's because the petitioner's attorney makes a tactical decision not to do it, because they hope the officer won't show up. And that gives them the opportunity to try to poke holes in the refusal report. And oftentimes they get dismissed because of that, because sometimes there's boxes that aren't checked out or they're legible. So out of the 6,000 cases, my understanding, again, something we could have put in a factual showing in the record, is that subpoenas are sought in 8% or less of these cases. So I think that's kind of important to point out.
So the trooper should easily be able to show up.
I'm sorry?
If they aren't issued that often, it seems odd that the troopers aren't showing up.
Well, you know, that was actually something that Gray considered. That was before the Gray court, that, you know, shouldn't that be part of the due process claim, the fact that, you know, there's and of course it wasn't enforcement, but it was just, there was a you know.
It's just an odd argument you're making. You're saying most times they don't want the trooper there, but when they subpoena the trooper and the trooper doesn't come, that's of no matter either. That just seems
I don't
odd.
know what I'm saying. I'm just saying that there's an additional process available in the very same article where the issuance statute applies, and that's all we're asking. Before you can state a due process claim and make a demand that the entire thing be dismissed outright, that you go that additional step. I think that's a reasonable balance between the liberty interest and the interest that you stated in Dar Casedo.
Thank you.
Thank you. Put her out of here.
I would like to clear up a couple things that I think would be inaccurate before I get into arguments. One would be the license is not restored. Okay, Mr. Monaghan won his DWI case, so he didn't get revoked for that. He was revoked for this. It is still an outstanding revocation.
So he doesn't have a license
He
right
does
now?
not have a license. And long story short, because of his driving record, he will not have a license for a very long time if this case stands, like a very long time. So he doesn't have his license back.
And if it doesn't, he
I'm sorry?
would, if it does not stand, would he have his license restored in the near term? Or are there other obstacles to that, given his driving
I don't think there's
record?
any other obstacle that I'm aware of, but he doesn't have it back, number one. Judge Singas, I believe you mentioned something about if they don't show the second time, do you win? That is not accurate. What happens is, if it's the second time is where the subpoena comes into play. So on the second time, if you haven't subpoenaed the officer, the ALJ is just going to go forward on the report of refusal. And if you wanted the officer there, you would have had to subpoena the officer, or you forfeit that. That would be a Gravy Aducci issue. But you don't automatically win. Like, typically, it would go forward anyway. In terms of, are you reinstated while this all goes on? If the officer doesn't, currently, it used to be that before COVID, they would schedule these hearings for an in-person hearing that typically took place within about a week or so. And you initially get a 15-day suspension by law that automatically terminates if you haven't had the hearing. Well, these days you never have the hearing because they do it virtually and they schedule them several months out. So everybody after 15 days gets their license back. If you go to the hearing the first time and the officer doesn't show, because they didn't show, you still get to keep the license. Whereas if you have the situation here and you now had to request an adjournment in order to subpoena, or in order to enforce the subpoena, according to DMV's regulations 127.7, it's very likely you're going to get suspended now for exercising the right to try and enforce the subpoena where the officer didn't even show after being subpoenaed. Now you would lose your license in all likelihood and extend any revocation because you don't get any credit for time served.
Just to be clear, what was the license reinstated here, given the
Well,
first adjournment?
The license would have been reinstated after the 15 days initially, and then it wouldn't have been suspended when the officer didn't show, and then it went forward with the hearing the next time. So,
So there was a period of time when the license was reinstated?
correct, approximately 4 months, I believe.
Okay, thank you.
So another issue is in Goldberg v. Kelly.
Wait, the license was reinstated while the subpoena question was being sorted out?
Well, there really wasn't a subpoena question.
Was the license reinstated?
Yes.
Okay.
There's a 15-day suspension by law when you get arraigned on a refusal case. And it's, as a matter of law, it terminates after 15 days.
Between that time and the time of the second hearing, it was reinstated?
Yes.
And if a second adjournment had been sought at that point to enforce the subpoena, it would have remained reinstated in that pendency?
Then it would fall under Rule 127.7, and the presumption is that if you request the adjournment as the motorist, you're likely to lose the license.
But it's discretionary at
It is
heart.
discretionary, but you very well could get suspended for exercising your right to have to make the officer come by a further process than we've already talked about. Now, in Goldberg v. Kelly, the Supreme Court talked about the importance of the right to cross-examine even in administrative proceedings, and said that the court has been zealous to protect the right from
Yeah,
erosion.
but the question here really is whether you need to get a subpoena to protect that right. It's not that you don't have the right, it's a question of whether you need to get and enforce a subpoena.
But realistically, as Mr. Demuth stated, there's 6,000 approximately hearings. Only 8% of them involve subpoenas to begin with. Keep in
Right, so
mind,
we don't even need to worry about those cases in a sense.
but there's two reasons for that. One would be a lot of times the officers actually do show up and they don't need to be subpoenaed.
Okay.
And the other thing would be almost nobody has the resources to do the subpoena process to begin with. So it's
Then
already.
that's not an issue in this case unless we're going to undo Gray.
No, what I'm saying is, though, in terms of due process, it's already a huge burden on process to make someone do the subpoena, and most people don't exercise that procedure to begin with. And to make it even harder, at some point you're eroding the right to cross-examine at all, because really nobody's going to go through this procedure. They're just going to say, fine, we'll take our chances on the paperwork, and the officers are going to all tell each other,
It's a
don't
little
show.
hard to say there's a denial of due process because somebody doesn't know to ask for something. Right? You could ask the ALJ to issue the subpoena, no? And your point is that they don't know to do it.
No, you have to do it. You can't ask them. It's,
Where do you go do it?
your lawyer has to do it.
These are attorney subpoenas,
They're
right?
attorney
There's-
subpoenas.
oh, so you need to get an attorney.
Well, you'd have to get an attorney, your attorney would have to do it. You know, if it's, quite frankly, a public defender is never going to do it. And so it would have to be someone that you're paying to do it. Very few people are going to do
But
this.
all those arguments are the same for the issuance of the subpoena and the enforcement of the subpoena. All those things you just mentioned are the same, but we've already decided that on the issuance of the subpoena.
But you haven't decided whether at some point enough is enough, and it's a violation of due process to make people continuously push stones uphill as the.
But it's hard for us to find a due process violation if the process wasn't followed. You didn't engage in the process.
I'm sorry?
There's a process that exists. You ask for the subpoena, you ask that the subpoena get enforced. We have rules and regulations about that. And now you're saying there's a due process violation, but you didn't ask for the second half of that.
I think it's fair to say that even if in the future that's going to be the process, it never was the process. And to hold someone to, like, you should have known, being aware of how it works in practice and the wording of
Has there
section.
been an appellate case that even after you've subpoenaed the officer and they failed to show, that required the petitioner to then go to Supreme Court to get enforcement?
No, Your Honor, and I believe the reason is there would never have been a case at all because you always won. Like DMV always dismissed those, and all of a sudden they've changed procedure and changed their precedent.
What
But
about this 2018 manual, I think he called it? What about that?
I've never heard of it, and I've never heard an ALJ mention it, and we've been talking about some things outside the record. I had tried to include something in my reply brief that ended up getting stricken, but even after Monaghan, I had a case where we subpoenaed an officer, and the officer didn't show. And so I said, Your Honor, I would request an adjournment to seek enforcement. Denied. And I'm like, but that's the procedure. Denied. Well, what?
Well, that might have been the nice due process claim right there.
But then, long story short, I brought it
Well,
to
let's
Mr.
keep it really short. Let me ask you this. I thought you had a very interesting point that obviously doesn't seem to be preserved otherwise in this argument that yes, after 15 days, there hasn't been a hearing, so now the license is reinstated, but oh, if you actually, if this court agrees with them that, yes, you have to seek enforcement, you're going to be penalized for that because the LJ might very well require that your license be suspended during that period. Strikes me that that's perhaps a
So-
very strong argument about due process, but I don't recall that preserved anywhere before us.
Well, whether it was, because I guess sometimes until the one side makes an argument, you're responding to it as opposed to preserving it on the front end. But finally, Your Honors, everything else aside, we have the substantial evidence question. And here, I think it's kind of outrageous that the arresting officer swore in his report of refusal that he did not read the refusal warnings, and then he swore in his bill of particulars that he did read the refusal warnings, and that in the first document he said it was another trooper who did it. In the other document, he said he did it. Everything is sworn.
Doesn't that really go to the value that cross-examination would have provided for?
If they had complied with the subpoena.
Well, what if the hearing officer just didn't think they needed to get to that? So your client denies being given a warning at all.
Correct.
What if the hearing officer didn't find that testimony credible? Then the apparent dispute between who gave the warning is immaterial.
Well, you're assuming, we're all assuming.
We don't know.
That the
I
warning
get
was
that.
read at all, or that it was read correctly. I mean, I can tell you.
No, I'm not assuming that.
But-
What I'm saying is the hearing officer did not credit your client's testimony that he wasn't given a warning. In the hearing officer's mind, that was done.
But the real question is, how could he credit that the warning was read when the officer swore that he read the warning and that he didn't read the warning at the same time?
You're saying the hearing officer could not disbelieve your client's claim that he was not given a warning?
Regardless of my client's claim, the report of refusal swears that
But
Trooper
couldn't they
Leggio did.
couldn't the hearing officer just thought a mistake was made?
When someone swears they both did something and that they didn't do it, it's kind of like swearing I was there and I wasn't there at the same time. I would say it presents you with choices of scenarios which renders it incredible as a matter of law, and therefore you can't credit it. Because, like, how would the court decide, were they really read? Who read the warnings? I find unanimously that these warnings were not only read, but read properly by Trooper who? Like, I don't know how you could make a finding here that there was substantial evidence that the warnings were read.
Thank you.
So, which is a whole separate
Yep.
dispositive issue, I believe. Thank you.
Thank you.